Morning, everyone. Thank you for kindly joining Harrison Clark Rickaby's webinar on business interruption insurance. As we've explained previously, for those who've joined us for these events, apologies now for any sound or technical issues and any teenagers that might disturb my study. It'll be based on broken into three parts. I'm joined by a fellow partner in the dispute resolution team, Jenny Raymond.
Hi there.
Thank you, Jenny. An external speaker, forensic accountant and partner at Baldwin's, Martin Chapman.
Good morning, all.
Thank you both for kindly joining me. So we'll be broken into three parts. From that perspective, I'll be talking about the type of claims that we're looking to make and have been making on behalf of our clients in and around business interruption insurance. Jenny will come on to talk about how those claims can be advanced, and in particular focusing on the test case being brought by the Finance Conduct Authority, the FCA, from that perspective. And then finally we have Martin talking about how one can quantify losses and best present those losses to the insurance company. Quite a complicated area, and one you really don't want your lawyers advancing for you, rather rely on the expertise of someone like Martin. Next slide, please. Okay, so on to the position of presenting claims itself in the remit that we're dealing with. If you listen to the insurance companies and the Association of British Insurers, you've probably read how it's certainly sort of doom and gloom approach. Less than 1% of any policies are likely to be paid out, according to those headlines. And it is understandable. The insurers are facing unprecedented level of claims are being made by a number of our clients and businesses within a number of sectors. Understandably so, a number of businesses are struggling to survive given the impact of COVID-19. The starting position that we'll be focusing on is the contract, the policy wording between the business and the insurance company itself. It's not just a policy, at the risk of stating the obvious to this audience itself. We'll be looking at the schedules as well, and also surrounding documentation leading up to and the inception of the policy. Any emails covering letters, telephone calls between you and the insurance company and also the broker, explaining the purpose of the policy, your instructions, what risks you've identified with the insurer that you're seeking to cover. It is quite a complicated area. Again, at the risk of teaching you to suck eggs, we are looking at the wording of these policies, and they can be ambiguous and gives grounds to make submissions and claims. This is the reason why we're a little bit more optimistic than the sort of headlines you'll see coming out from the insurance companies themselves as to the grounds they are defending these claims. To date, there is no definitive determined case law around some of these issues. There's very little case law around insurance claims dealing with pandemics. And that's why the FCAs case will be so important in clarifying and dealing with some of the ambiguity. As I mentioned, Jenny will come on to talk about that in some greater detail from that perspective. Next slide, please. The type of policies that certainly should be looked at by the businesses are those just covered on this slide. You may have seen in the news that the Lawn Tennis Association was successful in making a claim under its event cancellation policy for the Wimbledon Championship being cancelled this year. Again, excellent decision, whoever was involved in purchasing that policy. Clearly it's covered considerable losses arising from that event being cancelled. You've also probably seen travel insurance firms pay out millions in and around cancelled flights and holidays, with more to come. They're straightforward claims and are being met by the insurers. Trade credit claims are also being paid out from that perspective in combination with government backing assisted payments. The purpose of today and the presentation we're dealing with is around business interruption insurance. This is a far more complicated area, and we'll run through on the next slide, please, Amelia, the type of areas that we are particularly focusing on when helping our clients in this area. Typically, you're looking at the additional extensions, the non-property damage additional perils, it's known as, such as denial of access, specified illness, loss of attraction, and event cancellation. By and large, we've been met with a generic defence by the insurers, as these are not property-related damage claims. There is no compensation to be paid by the insurance company. By and large, this is a starter in each and every claim that we have advanced so far. Again, insurance companies are stressing at this point by reference to the type of examples they would normally pay out under these policies, which is flood and fire type examples. Again, we don't agree with that very strict analysis. The business interruption policy is to cover interruption and damage to one's business, and it's not to cover just physical damage as such. And certainly the extensions that are available and hopefully are in your policies would also cover these grounds. So as such, from that perspective, it's worthwhile taking a very detailed review of your policy and the supporting schedules themselves. Next slide, please, Amelia. From that perspective, we're seeing a considerable number of different types of variations and drafting of the clauses. It does lead to ambiguity, and they are unclear at times. Leading case law does state that one applies a degree of common sense and plain English interpretation from that perspective. As such, any ambiguity will be interpreted in the policyholder's favour from that perspective. And it's worthwhile, again, looking carefully at your policy wording in order to see what arguments and advancements you can make from that perspective. Certainly, when we're looking at sort of typical denial of access type cover, one's looking at the type of hurdles to address. Typically, you need to have an incident or an event taking place within a mile or 25-mile radius. Well, COVID-19 is having an impact throughout the entire country. So you can say with some degree of certainty that an incident will take place within that radius. Although that said, we've been advising a cricket club more recently where they're based in a rural setting, and it's unfortunately one hurdle we're unable to satisfy, and I've advised the client that under a denial of access cover, they're not likely to be successful with a claim from that perspective. Similarly, it's worthwhile looking at specified illness policy extension. Invariably, the insurance companies will have a list of illnesses that they do cover from that perspective. Some are exhaustive, but not all are exhaustive. Some will exclude pandemics. So again, a careful scrutiny of those clauses may give grounds for a claim to be made. Interestingly, some will include SARS, and the scientific name of COVID-19 include the word SARS. Again, at this stage, it's too early to determine whether those policies may qualify, but there is nothing to lose by advancing those claims. Interestingly, from an insurance company's perspective, is how they are defending these claims as well from that perspective. Quite often, they will state that these policies are not there to cover pandemics itself, but the wording of those policies are not necessarily always defined. So a careful scrutiny will help in order to ascertain what claims may be made. And as I mentioned here, lastly, any ambiguity, as the policies are generally on standard terms and conditions drafted by the insurance company, that ambiguity will be interpreted by the courts against the insurance company in favour of the policyholders themselves. Thank you. Next slide, please. So I'll now hand over to Jenny just to talk about how claims may be made and the impact of the FCA's test case. Thank you.
Thanks, Adam. Yes, obviously Adam's taken you through some of the sort of areas in which you can look to bring claims, and I'm going to look at sort of the steps to be taken on the basis that you think there is a degree of ambiguity and potentially a claim to be brought. The first thing to identify and to highlight, which again, not wanting to spell out the obvious, but the importance of notifying. We have had instances with clients who've come to us and haven't been aware of whether or not notification has been made. And often that's quite a strict requirement in policies, and typically it's within 30 days of an event giving rise to a claim. So we strongly recommend that those conversations are had with brokers ASAP to ascertain whether or not that notification, that box has been ticked in terms of speaking to your insurer and making them aware that you wish to bring a claim. On the basis that cover is accepted, and we are aware of a couple of clients who have had cover accepted a relatively straightforward way. Obviously, the next step would be to quantify your claim, gather as much evidence as possible, ascertain what your losses are, less any savings that you may have made, by way of example, any grants, access to the furlough scheme, etc. I won't touch on that much more because I know Martin will cover that off in more detail shortly. But as is often the case, and as with clients that have come to us on the basis cover is refused, it's what to do next. We would recommend preparing a formal complaint in accordance with the complaints procedure set out in the policy as well, and then bodying that up and doubling that up as a formal letter of claim setting out full details of the position. And obviously then in terms of your options, and again, not wanting to spell out the obvious, but on the basis that you qualify for the Financial Ombudsman Service, then that's always an option. We're aware that the FOS is working quite closely and liaising quite closely with the FCA in respect of these claims. And then ultimately, it's a decision as to whether or not you proceed through the courts. I expect much of that will be subject to how things progress with the FCA determination shortly. Next slide, please. So areas to consider, obviously causation and loss. Insurers are going to scrutinise the losses suffered. We are already seeing some resistance in terms of claims that clients are putting forward. Insurers are challenging the losses suffered on the basis that they were caused by other factors in addition to COVID-19. So by way of example, there would have been a downturn in the economy in any event. Therefore, the fact that a shop potentially has closed, even if it had been open, the chances are that it would have had a reduction in footfall and therefore a reduction in turnover in any event. So these are all questions that are likely to be challenged in due course, as well as internal factors. So whether there's been any staff shortages, mismanagement in respect of how the business has dealt with COVID-19 generally, are all issues that the insurers are likely to scrutinise going forwards. In terms of quantifying those losses, again, disclosure of management profit and loss accounts for previous years, as well as what forecasts and budgets were expected for this period, will be necessary in order to demonstrate the losses that the businesses have suffered. And typically, again, and particularly in terms of some of the extensions, there are normally limits as to what can be recovered. We're typically seeing with denial of access, notifiable disease extensions, that there's cover but provided for a period of, say, 3 months, up to a limit of potentially, by way of example, 500,000, $1 million. So again, and just reiterating what Adam said, it's just important to go back, look at particularly the schedules will set out what coverage has been provided, and making sure that that's adhered to in terms of putting forward any complaint. And equally, there may be exclusions set out in the policies, as well as I said, caps on losses. We are seeing in terms of defences to any claims, the insurers raising the point that whether COVID-19 is deemed contamination, so therefore is excluded under the policy, as well as the fact that we've had some businesses who'd already exited the premises in advance of lockdown coming into effect in sort of mid to end of March, and consequently there being an exclusion in the policy that if they're not in premises and in situ, then there's no cover. So again, it's just a question of going back through the policy, checking the wording and checking what applies in your circumstance. Next slide, please. So as we've already touched upon, and as I'm sure you're aware, the FCA is taking quite a proactive role in respect of business interruption insurance generally. Initially, it was started off with the FCA sending a letter to insurance companies effectively saying if it's a clear slam dunk case, you should pay out. But then that sort of quickly materialised. So at the beginning of May, the FCA announced it attempted to obtain court declarations to try and resolve some of the uncertainties regarding business interruption claims. And initially, it was met with a degree of cynicism. But as things have materialised, the FCA is clearly engaged with policyholders, particularly as well as going through and doing a sort of thematic review of 17 different insurance companies' policies and drawn out some of the key issues that arise across the board, and has now sought to put that before the court for a determination. The result and the outcome of the court proceedings will be legally binding on the insurers that are party, so it will be very important to see how this pans out over the next few weeks. Next slide, please. And so just to follow up on that, the claim was issued on the 9th of June. Defences and replies have also been filed and served. Skeleton arguments have now also been uploaded onto the FCA website, so are visible, and an 8-day court hearing is scheduled to commence next week. It's expected that there'll be a determination in August at some point. Obviously, then that could be subject to appeal. There is a whole raft of issues that are being sort of considered by the court, but to give you sort of a flavour of some of those, I've sort of mentioned a few on the slides there, but there's a whole issue around what does it mean by interference with the business in terms of prevention of access. What is it that policyholders will need to prove? There's a whole issue around who quite often people have in their policies around whether or not there's been government or local authority intervention and how that's defined and what does that mean. So the court's been asked to consider that. There's a whole issue around sort of proximity to a particular premises. So if there needs to be, for example, a notifiable disease within the vicinity of the premises, again, how does that need to be proved? Obviously, particularly at the outset, people weren't being tested for COVID-19. So is it sufficient that people can prove on the balance of probabilities that there was COVID-19 in the vicinity in order to tick that box? These are all some of the key issues that are going to come out and be explored further by the courts. So it is very much a watching brief, one that we'd recommend you keep a close eye on in the event that you are minded to bring a business interruption claim. There are regular updates on the FCA website. I think if you want to, you can watch the 8-day hearing live, but it'd be worthwhile just signing up for the regular updates. They are helpful, and it is sort of a useful exercise in terms of deciding what steps you want to take going forwards. Next slide, please. So in conclusion, and not wanting to repeat again what we've already said, but reviewing the policy is obviously your starting point. It's all about contractual interpretation. There's a large likelihood that there will be some ambiguity in those business interruption clauses. So again, scrutinising them, going through it and seeing what you think you're covered for, and whether or not there's any argument to challenge. Speaking to your brokers ASAP and ticking that box in terms of notification is key. And then on the basis that a claim is rejected, considering a complaint, bringing through the appeals process, and then ultimately whether or not you want to pursue the matter through the FOS in the courts is again something for consideration. And as I said, keeping up to date with the FCA developments is really useful exercise at this stage. I think at that point I will pass over to Martin, who's going to cover off the losses side of things. Thanks, Martin.
Good morning, all. Yes, I'm going to be talking about quantifying your losses. Probably will sound the most boring part, but if we're not going to get paid for it, why should we do this in the first place? So again, really important to get this right. If you just move on to the next slide, that'd be great. So what are we really trying to claim for here with business interruption? So I'm going to move away a little bit from COVID-19 because this is really practical advice. I'm basically just doing a business interruption loss calculation and how to get it right. The idea behind the business interruption policy is really to protect you and put yourself back into the position you would have been but for the incident that's just happened. Obviously, if we're talking COVID-19, it'd be that incident. Basically, when you took out the policy, it should have been defined on what basis you were insured for. Generally, there's two main ways: your gross profit or your gross revenue basis. So gross profit is mainly used for manufacturing and retail, the latter for service and professional businesses. When it comes to quantifying losses, gross profit is more complex than gross revenue, and what you have to be really mindful of is the term gross profit in insurance isn't quite the same as gross profit as a profit and loss account would show, and it's an area where people often get confused about exactly what they're insured for and get that wrong. So if we can move on to the next slide, please. So what are the key components of the BI policy that you've taken out? Well, hopefully when it was taken out and your broker was describing what the policy that you're about to take out and your insurer was telling you what you're taking out, there's some key elements that will be really important to your claim. So the time period for which the interruption will affect the business, which is known as your indemnity period, generally 12 to 24 months is the more common ones I see. I would have said probably 10 years ago, most people were insured on the 12-month one. I would say 24-month is becoming much more common. The idea being that you can claim up to that period from the date of the incident all the way through to the end of your indemnity period, as long as you're still suffering a loss. The next thing is the maximum amount that needs to be insured, so known as your gross profit or gross turnover, and I will come into the definition really of gross profit shortly. Obviously, if you're not paying for something, you can't claim for it, so you do have to remove any cost savings that you make. You might have other costs that you incur as you're attempting to get you back to where you were before, and these are often defined as increased cost of working, or ICWs. The other thing there is a little bonus, probably a bonus for me. It's always nice to tell clients that in certain policies and certain wording that if you've got your accountant who's helping you put together your claim, that you might be able to get a percentage of that feedback. Generally speaking, I've been getting around 75 to 80% of our feedback. There's areas they will always deduct, but it is possible to get it back, so it's definitely worth considering utilising expertise of accountants who are used to doing these claims. So if we move on to the next slide, please. So yes, that is very simple. That is a simple pro forma. And when I first started, I was told basically keep it simple, stupid. And I think that's a very good way of thinking about it. Why make your claim very complex? Really get the insurer on side, make sure that it's a very simple calculation. Supporting documents and evidence will then sit behind that. At the end of the day, this is what you're claiming for. So your loss of revenue, your profit margin gets you to your profit figure. You've then got some cost savings that you take off. You add your increased cost of workings, and then you add your accountancy fees if that's applicable, to basically work out what you can claim for. And if you keep to a very simple pro forma, it makes it easier for discussions. And then within each section, you would have the detailed workings behind it, but certainly show it in a very simple fashion. So if we move on to the next slide. So gross profit. Now, gross profit isn't just the figure that you take from your profit and loss account. There's some things that you need to consider, and I won't read all this slide out, which comes from the Chartered Insurance Institute. So basically, I would look at the last bullet point as being something that kind of defines, I think, in the easiest way. So it's calculated by deducting your variable expenses, which are also known as these uninsured working expenses, from your turnover figure, and then you adjust for any differences between opening and closing stock. So it's not just looking at that gross profit figure that you will see in your P&L account. You do need to consider some different elements to it. So if we move on to the next slide. So how do we calculate our gross profit? Well, the policy should define on how to calculate it, but in simple terms, if you think about it, that the gross profit that you achieve during the indemnity period after the incident, so the period you're suffering a loss till, and you compare that gross profit achieved in the corresponding period in the year prior to the incident. That's the simple way of doing it. So if you have made £100,000 the year before and you've only made £50,000 this year, and it's a full 12 months indemnity period, you've suffered a £50,000 gross profit loss. It's as simple as that, but it's not as simple as that. There's some things you really need to consider, and things that when I'm looking at claims on behalf of the insured, that we really, I suppose, look at to make sure that we claim for the full amount they can get. So things like seasonality. So seasonality in certain businesses will have a massive impact. If you're just looking at month on month, it can have a massive impact on what you're doing. What about a one-off impact? Something could have happened catastrophic in the year before, so those figures were low. You're still low this year, but actually that year before wasn't really your normal standardized profit. Business changes. What if you bettered the business and you've not had the impact of it? I did a claim about 6 months ago, 8 months ago probably now, of a restaurant, that had a big refurb job, and they had added additional bar space and additional tables. Unfortunately, a car crashed through its shop window about 2 weeks after that had happened. So they only had 2 weeks of trade with this betterment going through. When the insured put a loss adjuster on this, they literally looked at 1 year over the other. And that basically just meant that the loss didn't look very good. What we actually had, we had 2 weeks of this betterment, and that needed to be taken into consideration. So we almost had an uplift in the prior year of around 10 to 15%, which when we put through the loss, I think it almost doubled the loss, which was obviously very pleasing for the insured. And we went through settlement and we agreed pretty much the figures that we put forward in our claim with the loss adjuster, which again is rare. And I think in this occasion, we did get 85% of my fees back. So almost doubled their claim and got my fees back, and a very happy client, and always the good thing to think about. But if you just think about 1 year and the prior year, that will not make sure that you get your loss right. You do need to think of these other things that can be considered. So if we move on to the next slide, please. So cost savings, well, if you're not incurring the cost, then you can't really claim for it. So anything that you're not incurring during the period of interruption needs to be deducted from your calculation of loss. So you might have a reduction in your light and heat, you might have less motor expenses, you might not be paying for temporary staff costs. So if we take the idea of the restaurant, and they had temporary waiters and waitresses and bar staff, they obviously didn't employ them, so they couldn't claim for them. If we're thinking in COVID-19 territory here, you're going to have to be thinking about furloughed staff and what costs you've already, I suppose, covered by having, I suppose, government help here. You might be topping up that to above the 85%. So you really need to think about what you've claimed for, what you've looked at with the government here. So this will also need to be negated from your losses. So if we move on to the next slide. Now, increased cost of working is a really important area. So if we take the restaurant again as a good example, what we agreed prior to the, prior to working out the loss, we looked at how can we get ourselves back to the pre-loss position. So we agreed with the insurer to have almost an opening party, which we agreed through the increased cost of workings. The idea being that the sooner that we can get the business up to its pre-loss position, the better. So by incurring some additional costs for advertising and some free drinks, we had some free food, this kind of cost, this opening party basically brought them back to their pre-loss position much quicker. Always agree your increased cost of workings with your insurer if you can prior to incurring the costs. Sometimes you just can't, so you might have additional overtime costs, you might have additional storage costs, all these types of things that I'm not going to read through this list. But if you're going to do advertising to do a reopening or something, get it agreed. Don't go and incur massive costs if the insurer is then going to turn around to you and say, well, we're not covering that, we don't see the purpose of it. Obviously, the purpose of it is to get you back to that pre-loss position as quickly as possible. So these are really important areas to look at. So if we move on to the next slide. So some key things really for me to think about when I'm putting a claim together for my clients is I want to have good cooperation with your insurer. The better dialogue you have, I always think that the more likely you are to get a good settlement with your insurer. They also want to show that you've also got to show that you're trying to mitigate your losses. So again, your ICW is really there coming to their own. Again, it's a good way of trying to show that you're mitigating your losses. Have good communication with your insurer or their appointed advisor, typically a loss adjuster. So I've got a claim at the minute, a COVID-19 claim, and the loss adjuster is being very reasonable. On the other side, the insurer have appointed forensic accountants themselves, and the initial list to our insured was the biggest wish list I've ever seen in my life, and it didn't really fit in for the business that this guy was operating. It's obviously a wish list they use for all their clients that they're looking at, the forensic accountants on the other side. And we've had to have good dialogue to say, well, that doesn't exist. This is not that type of business. That doesn't exist. You would never get that, to make sure that we can manage the claim process better. When you do come to putting your claim together, make sure that you do it with good supporting documentation. Don't just put in a figure and then not support it with anything. If you go for the simple pro forma, it's much easier then to attach your exhibits, appendices, your workings, your supporting evidence to that. Be reasonable. Don't make a ridiculous and speculative claim. I work for insurers as well. If I see a claim that I think is unreasonable or ridiculous or speculative, I will take it upon myself to try to knock it down as hard as I can. Obviously, I'm working with the insured on that case, but don't put the people who are looking at the claims to the insured's back up. Agree your ICWs with the insurer if possible, and certainly think about discussing interim payments. The idea being is that you're not just waiting for a big lump sum at the end. These losses, if you've got a indemnity period of 12 months, 24 months, going a long time, it might not be easy to know how long your loss will go on for. So you can discuss interim payments and get paid in a timely fashion. That's always a good way of approaching it. Again, with your accountant, if they're looking at it, what they might do is do the initial claim. We work out a system of interim payments for 6 months, and then we revisit the claim again. So we're not actively involved for the full 6 months. Think here, we've talked about full and final settlement. Again, an area that I'm always mindful of with my clients, that they get what they think is a really good offer, almost on the first assessment of the claim, they accept it, forgetting that their indemnity period is 24 months. They could be suffering losses up for 24 months. Now, if that's the case and you've taken full and final settlement, you've then got to try to get your way out of that, which is going to be very difficult. Obviously, in the COVID-19 environment, we're discussing whether full and final settlement is going to be the, I suppose, if the test case then changes the decision. I think it's something we would need to consider. So do think about accepting a full and final settlement. I would rather go for the interim payment process and look at when you think you're back to your pre-loss position. So if we move on to the next slide. And just to finish, it's not just really looking at BI here. I think just thinking generally about insurance is really important. I have a lot of conversations with our clients about insurance, and talk to your insurance broker about what your insurance covers. There's nothing more frustrating than speaking to a client who actually is paying a premium and they don't even know what they're covered for. BI, don't be underinsured. Do keep it constantly reviewed. If your gross profit, your business is improving, it might not be right for you when you took out the policy. Your indemnity period may no longer be right. The worst thing you can do is be underinsured, because it will have a massive impact on the quantum of your claim. I just said earlier, what else are you not covered for? If your business has become very digital, do you need cybersecurity insurance? These types of things are something you should be considering. And I think my last comment really is just the way I always talk to my clients about dealing with insurance. Yes, you are paying up front, but you're paying today to protect your tomorrow. So yes, you're paying up front, but the worst thing is not to be insured for something that then eventually happens. I think that's now my slides done. I'm now going to hand back to Jenny, who will bring a few other further points. Thank you.
Thanks, Martin. And just to touch really on what Martin's just been sort of highlighting, and just to conclude, a couple of further slides. In terms of other options that you can look at this stage, in terms like reducing and refunding premiums, is something that insurers do seem to be accommodating at this stage, particularly if your business has shrunk or the nature of the business has changed. It's worthwhile having those discussions with your broker. I think we're seeing that there's been a reduction in premiums and a refund in terms of premiums for vehicles that are being sworn. If your stock, for example, has reduced, your turnover is reduced, then there's the potential for premiums to be refunded in that respect as well. Therefore, it is just important to sit down and look at the policy holistically, liaise with your broker, and to see whether or not there are any refunds that could come your way, albeit appreciate in the scheme of things probably fairly modest, but at the same time, you know, it's a worthwhile exercise completing, and we are seeing clients receive monies back, which is always a positive. Next slide, please. And finally, not to end on too depressing a note, but just sort of drawing attention to some of the other claims that may be waiting in the wings in light of COVID-19. Obviously, people are now starting to return to work, so just highlighting the employers and public liability, potential claims that could come in the event that, you employers are accused of not keeping staff physically and mentally safe, and similarly with schools and care homes. Obviously, I've said there's directors and officers insurance on the basis that potentially the business hasn't effectively managed the crisis, and or there's been any breaches of health and safety. We've also seen claims arising from linked to professional indemnity on the basis that, for example, brokers may not have reviewed policies and given consideration to COVID-19 when they were renewed in potentially February or March time. And we've also seen claims arising in the construction arena in light of projects not meeting deadline dates, etc. We've also interestingly had some claims. I think there's been an increase in fraud, and we've seen that with some of our clients who have looked to source PPE, had contracts in place with some national retailers, and have been unable to satisfy the terms of the contract because the supplier has actually been fraudulent, and so they've had to look to source from elsewhere. So again, it's just about making sure people are aware and alive to some of the issues that are ongoing in the marketplace at the moment. And I think that comes to an end to the sort of formal webinar and the slides, but I'll pass back now to Adam to go through a Q&A.
Thank you, Jenny. Thank you, Martin, both for kindly running through sort of how to present claims within the business insurance arena. Just to echo some of the points just been made, and to stress, a number of our broker clients are probably going to whisper in my ear, if we don't stress, we're not encouraging anyone to cancel insurance policies, but do take a look, because there is an opportunity to save on premiums from that perspective. Okay, so just looking at some of the questions we've had sent in advance of today. One straight away, I think it's got your name on this one, Martin, if that's okay. Looking at presenting your losses to the insurance company, obviously a number of businesses, our respective clients as well, have taken advantage of government funding from that perspective. What sort of impact does that have on your losses and submitting that to the insurance company?
Well, this will have an impact, because you've got to consider obviously double claim here, that you've obviously had government help, and then you've got to think, well, actually now can I claim it through my insurance policy? And each type of help is going to have a different way of looking at it. For instance, if you've taken a grant that's repayable, you've then got to think about how you're going to repay it. Does that then become claimable in the fact that you've got repayments to make? How did it keep you going during the period, I suppose, the incident occurred? Furlough staff will be an interesting one, that people furloughed staff. Obviously, you can't claim for that if you've obviously had the income coming back from the government, but what if you've done the top up? Then you might be able to claim that back. So I don't think it's going to be as straightforward as just taking it off. Each one will have its own merit, I think, and I think that's really important to look at each type of funding that you've had and how that will impact on your loss. It's not going to be straightforward, which I don't think any of these losses are. The first couple that I've had are not straightforward. Obviously, the wording, the indemnity policy, all these types of things are being looked at. So that's my comment on that.
Okay, no, thank you for that. One for you, Jenny. Martin touched on this as well in his presentation. For those clients who have already managed to make some form of recovery and have entered into a settlement agreement with the insurance company on a full and final basis, will that be affected in any shape or form with the FCA's test case? Will there be an opportunity to potentially reopen if the FCA obtains a more favourable decision?
Thanks, Adam. Yeah, I know Martin did touch on this in his talk. And obviously the starting position is if it's full and final, then it's full and final. But we have sort of reason to believe that there's a possibility that in light of the FCA test case, that there may be direction from the FCA that enables policyholders to reconsider the offers that they've accepted and potentially look to unwind that full and final agreement in light of the outcome of the test case. So again, it's a bit of a watching brief, but it may be one that isn't quite as final as perhaps is usually the case.
Okay, well, thank you for that. Yeah, I think it is a watching brief at this stage to see how the test case unravels and what sort of judgment the courts make, and then particularly how that's applied by the FCA. Okay, question coming from a business. It says, the government required us to close our events business. What sort of clauses can we claim under? Again, it's back to what are the terms and conditions of the insurance policy itself, checking out those additional perils in place, have a look at whether you've got specific tailored cancellation policies, as they're generally easier to claim under. Failing that, have a look at whether there's any notifiable disease cover, and finally, sort of denial of access. So your common clauses that may give grounds for claims. And if you're looking at providing events and they're being cancelled because of the lockdown and COVID-19, then you're going to have to check the contracts you have with your customers as well as to whether you're still entitled to charge or agree some form of postponement. So again, it's down to that individual business and the contracts in place. One, I think this is for you, Martin. Does my indemnity period mean I can claim for the full period?
The indemnity period is a funny one. I often get this asked by clients when they get confused that, well, I've taken out a 24-month indemnity period. Obviously, I can keep claiming for 24 months. It still goes back to getting to the pre-loss position. So if you get to the pre-loss position in a month, then it's a month that you can claim for. If it's 6 months, it's 6 months. It's getting back to that pre-loss trade. Obviously, by looking at the policies that I've already seen, there's restrictions, which I think you touched upon, which will have a different meaning on the indemnity period. And I think this will be a legal area really for how long you can claim for. But the general principle still remains the same, which is you can claim until you get back to your pre-loss position. And that's always been the same. So hopefully when insurance policies were taking out, your broker explained that's what it meant, not that you can take up for 12 months or 24 months, because that's not what it's intended to do. It really is intended to get you back to the pre-loss position. And it will just be the specific wording that will impact on COVID-19 rather than the general principle, which is, yes, you can keep claiming up till you get to the pre-loss position within that indemnity period. So yeah, I think another interesting area for the FCA to look at and consider what that actually means, because I imagine there's going to be some very disgruntled insured who will say, well, I had an indemnity period of 24 months, why have I not claimed for that? That's not fair. And I think there then could be some claims against brokers, as we talked about, maybe not explaining the situation properly, which could be the case. And I would think if I was a broker, I think I'd be looking about some of the policies that I've sold and whether I sold it with the right guidance. I don't know. But that's certainly an area that I think will be a challenging area coming forward.
Okay, right, thank you for that. And then Jenny, a question for you from another client. The company has infectious disease extension to the business interruption insurance policy, which they believe they should close them for when the business is shut down. I'm thinking they're in a good position. But as we've seen, unsurprisingly, insurance companies have declined cover. As they say, the closure of the business is as a result of the government's direction and not because of notifiable disease. Any thoughts on whether that can be challenged at all?
Again, this is an area that the FCA is looking into, and it's forms part of the test case. So to a large extent, again, it's a bit of a watching brief, but certainly think there's mileage in arguing. I think it can be argued either way, and again, it's down to contractual interpretation. So it will be interesting to see how the court considers these issues over the course of the next few weeks, and the judgment that it comes down to in due course. Like I say, it's probably, we're looking at sort of the next month or so before we'll have any kind of determination, but I certainly don't think it's quite as closed a door as the insurers are leading us to believe at this stage.
No, I will clearly echo that as well. I think there's certainly a degree of optimism more than how it's been presented by the insurance companies in the current climate. And we all wait for the FCA's progress with the test case and see how that may change the goalposts. Okay, that concludes our questions. So first of all, thank you very much to Martin and Jenny for their expertise in helping with the presentation today. Thank you also to everyone who joined for the presentation and this webinar. I understand it now concludes this series of in-house updates. Our marketing team and Beth Beattie, who leads in this area, will be in touch with a series for the autumn. Please do get in touch with Beth or the team on asktheexpert@hcrlaw.com. If you've got any requests, any suggestions for topics for training, that would be really appreciated from that perspective. Otherwise, it's just finally to say thank you very much for your time. Once again, thank you to Jenny and Martin, and that concludes today's webinar. Thank you.